In this video, I'm going to give you clear and concise answers to 50 multiple choice questions so that you can ace your exam with confidence. We're going to move quickly, so hit the pause button if you need more time. Let's get going 50 exam questions in 30 minutes. Good luck.
Certain economic principles are of considerable importance in the valuation of real estate. The principle that no buyer will pay more for a product than the price he can pay for a reasonable duplicate is known as the principle of substitution, balance, competition, conformity. The answer is substitution. The principle of substitution states no buyer will pay more for something if there is a suitable alternative of equal or lesser price. All valuation approaches are based on the principle of substitution. In the market data approach, the principle states that the maximum value is set by the cost of purchasing an equally desirable and valuable substitute property. The cost approach states that the maximum value is set by the cost of acquiring an equally desirable site and constructing improvements on the site. In the income approach, it states that the maximum value tends to be set based on the rates of return of comparable properties. Therefore, any comparison is actually based on the principle of substitution. The fact that the ability to buy and sell land affects its value is the basis for the essential element of value known as transferability, scarcity, utility, demand. The answer is transferability. The essential elements of value are demand, utility, scarcity, and transferability or dust. The fact that land has a number of important uses is the basis for the essential element of value known as scarcity, utility, transferability, demand. The answer is utility. The essential elements of value are demand, utility, scarcity, and transferability or dust. The value of the best property in the neighborhood will be adversely affected by the presence of comparatively substandard property in the same neighborhood. This is known as the principle of regression, contribution, balance, progression. The answer is regression. The principle of regression states that the value of better quality property is adversely affected by the presence of lesser quality property. The principle of progression is the opposite. The actual amount that a parcel of property sells for is the market price, assessed value, market value, fair market value. The answer is market price. Market price is the actual price paid. Market value is the listing price. Assessed value is used by the tax assessor. Which principle of value describes the value produced by adding an improvement or upgrades to a property? Highest and best use. Principle of contribution. Principle of anticipation. Principle of substitution. The answer is principle of contribution. The principle of contribution determines if an improvement or upgrade adds value to the property. This is determined by what the market will pay for the improvement or upgrade, not the cost of the improvement or upgrade. To realize the maximum value of property, a reasonable degree of sociological and economic homogeneity is necessary, but it should not become monotonously uniform. In real estate, this concept is called the principle of progression, conformity, contribution, correlation. The answer is conformity. The principle of conformity states that maximum value is realized if the use of land conforms to existing neighborhood standards. However, these factors should not be so uniform as to become monotonous. A contract could be rescinded due to any of these: fraud, mistake, misrepresentation. The answer is any of these. To rescind a contract is to cancel, terminate, or annul it and restore the parties to their original positions. Contracts may be rescinded due to mistake, fraud, or misrepresentation. If this happens, each party returns money received to the party it was received from so that all are restored to their original positions. A buyer and seller entered into a purchase contract. The seller later stated that she did not wish to sell the property. In order for the buyer to force the seller to sell, the buyer may use what remedy? Liquidated damages, assignment, unilateral rescission, specific performance. The answer is specific performance. Specific performance is an action brought in court to compel a party to carry out the terms of a contract. A seller could sue a buyer, requiring him to buy the property, and a buyer could sue a seller, requiring him to sell the property if either party defaults. Liquidated damages is available only to the seller. Time is of the essence is a concept of real estate law concerning conditions of record, performance, leases, delivery of title. The answer is performance. Time is of the essence means that both parties agree to perform by any date specified in the contract. If one party is ready to perform by a specified date and the other is not, the party ready to perform can declare a default of the contract. It does not require either party to perform before the specified date. This clause is found in the earnest money contract. A contract of sale that is contingent upon the buyer's ability to obtain leases and advances. Void because it violates the statute of limitations. Unenforceable, enforceable, illusory. The answer is enforceable. This contract has a contingency and is conditional. It is enforceable, as the seller can sue for specific performance if the buyer does not conclude the sale and there is evidence to indicate a favorable lease could have been obtained. A contract may be cancelled by mutual agreement between the parties, by an attorney for either party, with 30 days' notice by either party, under no circumstances. The answer is by mutual agreement between the parties. Mutual agreement or mutual rescission may be used to terminate a contract. A month-to-month tenancy must include which of the following to be valid? All of these. Oral or written contract. Offer and acceptance. Consideration. The answer is all of these. Since a lease is a contract, it must have consideration, offer and acceptance, legal object, and competent parties. If it's for less than 1 year, it can be oral. A remedy in court compelling the seller to sell the property is known as foreclosure, specific performance, execution, equity of redemption. The answer is specific performance. Specific performance is an action brought in court to compel a party to carry out the terms of a contract. A seller could sue a buyer, requiring him to buy the property, and a buyer could sue a seller, requiring him to sell the property if either party defaults. A seller rejects a written offer made by a buyer, alters the terms of the offer, and has the new offer delivered to the buyer. This situation describes a offer and acceptance, change order, meeting of the minds, counteroffer. The answer is counteroffer. If a seller does not want to accept an offer exactly as it is made, she may decide to reject the buyer's offer and initiate a new offer, which is called a counteroffer. The seller sold his farm under a written contract of sale that made no statements about assignment. The buyer assigned the contract of sale to a new buyer. Until the sale is settled, the equitable title is held by the new buyer, first buyer and new buyer, seller. The answer is new buyer. All contracts are assignable unless there are terms specifying that they cannot be assigned. Obligations move to the person whom the contract is assigned to, in this case, the new buyer. A legal procedure or action brought by either the buyer or seller to enforce the terms of the contract is known as contract. Legality of object. Specific performance. An option. The answer is specific performance. Specific performance is an action brought in court to compel a party to carry out the terms of a contract. A seller could sue a buyer, requiring him to buy the property, and a buyer could sue a seller, requiring him to sell the property if either party defaults. If a party to a valid real estate contract becomes bankrupt while the contract is executory, the contract is voidable, terminates, is still enforceable, must be renegotiated. The answer is terminates. All contracts are terminated by bankruptcy. If a buyer makes a counteroffer to the seller's counteroffer, the seller's counteroffer is modified, still in effect, terminated, but can still be accepted. The answer is terminated. Counteroffers always terminate the original offer or previous counteroffer. An executory contract may be assigned under any circumstances, unless prohibited in the contract. If provided for in the contract, under no circumstances. The answer is unless prohibited in the contract. All contracts are assignable unless prohibited within the terms of the contract. If a contract offer is not accepted within the specified time period, it can be extended by the offeree, terminates, cannot be countered, is renewed. The answer is terminates. Any offer not accepted may be countered. Offers terminate either by the date and time listed in the offer or by passage of a reasonable amount of time. Only the offeror can extend the time period. Any offer not accepted may be countered. An executed sales contract may be assigned under what conditions? Under no conditions. Only if the contract provides for it. Unless the contract prohibits it. Only with the seller's permission. The answer is under no conditions. Executed contracts are closed and cannot be assigned. Only executory contracts may be assigned. Crossing out part of the printed matter in a contract is allowed but should allow a reader to see what was crossed out. Unauthorized practice of law. A violation of commission rules. Illegal. The answer is allowed but should allow a reader to see what was crossed out. When a printed item does not express the wishes of a party, it may be crossed out. However, the crossed-out items should still be legible. If a seller accepts and signs an offer made by a purchaser, the next thing the listing agent should do is notify the buyer's agent immediately. Notify her broker immediately. Sign the contract for her broker. Notify the buyer. The answer is notify the buyer's agent immediately. The listing agent should notify the buyer's agent of acceptance of the offer so the agent can notify the buyer about acceptance. If a property is destroyed before the title or possession has passed, the contract is voidable by the seller. Valid. Voidable by the buyer. Void. The answer is voidable by the buyer. Real estate contracts have terms for what occurs if the property is destroyed before closing that make the contract voidable by the buyer. The buyer often may take the seller's insurance proceeds and buy the property or terminate the contract. If a seller has already accepted one offer and later accepts another offer on a contingent basis, this contract is called a contingent contract, blanket contract, backup contract, secondary contract. The answer is backup contract. A backup contract is contingent upon the first contract failing. If a property is destroyed before the title or possession has passed and the buyer terminates the contract, she has no recourse, must sue for her money, must have insurance to cover it, is entitled to her money back. The answer is entitled to her money back. The contract is voidable by the buyer, who can terminate and have her earnest money returned in full. If a party to a valid real estate contract dies while the contract is executory, the contract is voidable, terminates, must be renegotiated with the estate of the deceased party, is enforceable on the deceased party's estate. The answer is enforceable on the deceased party's estate. Death does not terminate contracts. Contracts are terminated only if there is no one left to perform. If a seller signs an offer made by a purchaser, the first thing the listing agent should do is submit the contract to the buyer, give a copy to the seller, take the contract to the broker, sign the contract for her broker. The answer is give a copy to the seller. Upon signing any document, the parties should be given a copy. Today most contracts are electronic, and this is taken care of immediately after the signature occurs. If not using electronic forms, the real estate professional needs to make sure the seller has a copy before leaving. If the current or previous owner of a property was infected with AIDS, when should the owner or real estate professional disclose this information to a potential buyer? Only if asked by the buyer. Never. Always. Only if directed by his/her broker. The answer is never. AIDS is a handicap under the Federal Fair Housing Act and is protected. Therefore, a question about AIDS, as with all protected classes, can never be answered by the owner or any real estate professional. If a seller is considering one offer and another offer comes in, the listing agent should hold the new offer, reject the new offer, submit the new offer if better than the first, submit the new offer. The answer is submit the new offer. The listing agent has no obligation to present the offers in the order they are received or to present the highest offer first. However, the listing agent must promptly submit all written offers to the seller. In the purchase contract, if the seller refuses to close, the buyer's remedy is liquidated damages, novation, rescission, specific performance. The answer is specific performance. Specific performance is an action brought in court to compel a party to carry out the terms of a contract. A seller could sue a buyer, requiring him to buy the property, and a buyer could sue a seller, requiring him to sell the property if either party defaults. A buyer does not have liquidated damages as an option if the seller defaults. If a seller has entered into an executory contract and wants to make a counteroffer on another offer that just came in, the counteroffer should be contingent upon acceptance by the buyer of the contract, contingent on the contract not closing, contingent on the first contract closing, only drafted by a lawyer. The answer is contingent on the contract not closing. The seller may not accept a new offer and should only accept offers that are contingent upon the first contract failing to close. Unless the sales contract stipulates to the contrary, the risk of loss or damage to property before legal title or possession is transferred to the buyer falls on buyer's title insurance, seller's insurance company, seller, buyer. The answer is seller. The seller is liable for damage until he has given either possession or title to the buyer. The buyer becomes liable once he receives title or possession. Real estate values are inflating rapidly. Despite having already signed a written contract of sale, the seller refuses to complete the sale. The remedy the buyer may choose is rescission, liquidated damages, suit for specific performance, action to quiet title. The answer is suit for specific performance. Specific performance is an action brought in court to compel a party to carry out the terms of a contract. A seller could sue a buyer, requiring him to buy the property, and a buyer could sue a seller, requiring him to sell the property if either party defaults. The phrase in a contract indicating that a party is in breach of the contract if he or she fails to perform by the specified as deadline is referred to as time is guaranteed. Timeliness is crucial. Timeliness is of the utmost importance. Time is of the essence. The answer is time is of the essence. Time is of the essence states that each party will perform all terms by the date listed in the contract. The substitution of a new contract, which terminates and replaces an existing contract, is called replacement, substitution, novation, assignment. The answer is novation. Novation removes all obligations and liabilities of the first contract, replacing it with a new contract. Assignment still leaves some liabilities from the first contract. When a new contract is introduced through novation, the old contract is amended, must be rescinded by the parties, remains in effect, terminates. The answer is terminates. Novation removes all obligations and liabilities of the first contract, replacing it with a new contract. Assignment still leaves some liabilities from the first contract. It is said that a valid contract must have legality of object. Which of the following best describes legality of object? The contract must not be for an illegal purpose or against public policy. Either party has the legal right to cancel the contract, provided legal notice is given. All parties are of legal age and agree upon the legal consideration to be paid. A contract between competent parties that is legally enforceable. The answer is the contract must not be for an illegal purpose or against public policy. To have a valid contract, 4 elements are needed. These are competent parties, mutual consent, legal consideration, legal object so that the contract is legally enforceable in a court of law. When a signed sales contract is assigned, the dispersal of earnest money is determined by the listing broker. An agreement between the parties. The seller and listing broker. The law of agency. The answer is an agreement between the parties. The assignment contract sets the terms for how items within the contract being assigned will be handled. When a seller breaches a sales contract, the buyer may do all of the following except rescind the contract, collect liquidated damages, sue for monetary damages, sue for specific performance. The answer is collect liquidated damages. Liquidated damages are available only to the seller. The buyer has all the other remedies listed. When one party fails to live up to her contractual obligations, it is known as breach, termination, novation, assignment. The answer is breach. Failure to meet contract obligations is known as breach. When a contract is breached, it is not automatically terminated. Novation means substituting a new contract or party. Assignment is transfer of one's rights under a contract. When presenting an offer to a seller and the seller has legal questions about the contract, the real estate professional should Answer only the questions the professional is sure about. Answer the questions to the best of his or her knowledge. Advise the seller to consult a lawyer. Advise the seller to consult the broker. The answer is advise the seller to consult a lawyer. Legal questions should always be referred to a lawyer. When more than one offer is received, the seller may accept or make a counteroffer on the highest offer only, the first offer only, any offer received, all offers simultaneously. The answer is any offer received. Regardless of when the offers come in, the seller may choose to accept or counteroffer any offer. An agreement between competent parties based upon legal consideration creating legally enforceable duties and obligations is a definition of legality of object, contract, offer, specific performance. The answer is contract. To have a valid contract, 4 elements are needed. These are competent parties, mutual consent, legal consideration, and legal object so that the contract is legally enforceable in a court of law. Note, this definition has the 4 required elements of a contract: competent parties, mutual consent, legally enforceable duties, legal consideration. A broker wrote an offer to purchase for a buyer, which the buyer signed. The offer did not provide for an earnest money deposit. Which of the following statements is true concerning this situation? Acceptance by the seller will not form a contract. A contract will be formed on acceptance without the existence of a deposit. The broker may make a deposit for the buyer without informing the seller. The broker should not present the offer to the seller. The answer is a contract will be formed on acceptance without the existence of a deposit. The purchase offer becomes a binding contract when the seller accepts the buyer's offer by signing the offer submitted by the buyer, and as the buyer is notified of the seller's acceptance. The broker must present the offer, whether or not there is earnest money. There is no requirement for earnest money deposit, as earnest money is not the consideration for the contract. A buyer who gives broker 5 days to secure an acceptance of his offer is bound by the termination date of the listing. Must await approval or disapproval by the seller. Must deposit earnest money at least equal to 5% of the offer. Can withdraw before the 5 days have passed if he has not been notified of acceptance by the seller. The answer is can withdraw before the 5 days have passed if he has not been notified of acceptance by the seller. A buyer can withdraw his or her offer any time before notification that the offer is accepted. If the offer is not accepted within the specified time period, the offer is automatically withdrawn. A contract created by actions rather than oral or written words is called a determinable contract, implied contract, actionable contract, express contract. The answer is implied contract. An implied contract is an agreement inferred from the actions of the parties and is not created by words or writing. An express contract is one that results from a written or oral agreement. A buyer gave a broker a written offer to purchase property, which contained a 10-day acceptance clause along with a $2,000 deposit. On the 5th day, prior to acceptance by the seller, the buyer notified the broker that he was withdrawing his offer and demanded the return of the deposit. Which of the following statements is true? The buyer cannot withdraw the offer until the end of the 10-day period. None of these. The buyer may revoke his offer any time before he is notified of the seller's acceptance, but he will lose the deposit. The buyer may revoke his offer any time before the seller's acceptance is communicated to him and may obtain the return of his deposit. The answer is the buyer may revoke his offer any time before the seller's acceptance is communicated to him and may obtain the return of his deposit. An offer is not legally binding until it becomes a contract. Therefore, the buyer may terminate an offer, regardless of how it's worded, any time before there is communication of the seller's signed acceptance of the offer.
You made it to the end. Congrats! If you're looking to study more right now, head over to our exam practice question playlist. We have hundreds of questions waiting for you. Subscribe to our channel and you'll get notified when we release our next exam prep tools to help you pass the real estate exam.